Recording, okay. Now the point of recording here is to, as I said, give access to everybody of the notes, if you want to call it that, or just a link to hear it again. And as you know, I usually bring written materials. Today I brought a diagram that I will go ahead and hand out before, or at the start of doing things here. And things here, what are things here? What we're doing here today is, I believe the lesson title is Trusts 101, under the course title of Wills, Trusts, Estates, and Probate, and everything you'd want to know about that, or some condensed version of that. And we're offering this through the Enrichment of Life Movement, a nonprofit organization that's hosted at the First United Methodist Church of Marietta. And so this is the, I think, third of 7 classes about everything you'd want to know about these, what we call trust and estates areas. I'm Robert Meyering, and I have a trust and estates law firm based in Vinings here in Cobb County, right in Vinings Village. And I've been doing this trust and estates kind of thing for a while. So, thanks for bearing with me with the kind of setup of what we're doing and being able to take notes in this way. And if it's not too distracting, I'm actually going to hold my iPhone for audio purposes, for recording purposes. And I'm very practiced at this, not talking, but I walk my dog, and she's this crazy husky that the line's always taut no matter where we go. And so I've gotten very practiced at this and running because my husky taught me how to run. It was this husky, right? Well, here.
Don't mess it up.
Yeah, we don't want to mess it up. But, as dear as they are, dogs, they do pass, and I have a new husky, and this one's just absolutely crazy, whereas the other one was just the best walker, the best runner. So life is short, especially for canines, but more to the point about what we're doing here is we're talking about trusts. And I figure we'll talk about 3 basic main components of trusts. First of all, what are they? How. And second is kind of how they work, those purposes. If you have something that's really awesome and cool in the areas of estate planning, and that's called a trust, it would be awesome and cool in how it applies to your life. And if it makes your life easier, or it makes your estate plan easier, or it helps with the whole issue of probate, or avoiding it, or whatever probate is, we'll kind of touch on that, because trusts do have a purpose and a very direct tie-in to the handling or the avoidance of probate. And sometimes that's a huge advantage to getting a trust, is sometimes people just come up with the idea that, handling the probate for my parents or my sibling or somebody else and dealing with the rest of the family was absolutely terrible. It was the worst thing I've dealt with in years. And often that's a very difficult point in a family's history when somebody passes away and old arguments come up and there's some assets or value or property or money or cash or land that needs to pass to the next generation or on to the surviving spouses, and arguments come up really quickly, especially with mixed families, blended families they call them. It's more than half of all families anyway. And marriages, what happens to half of all marriages? Right? They often end in divorce. Other marriages, end with a spouse passing, and there's assets to be left. And this is where trusts can come in so as to allow these assets, property, money, things to pass to the living, the surviving family, surviving friends, surviving charities. Just like this Enrichment of Life Movement, Inc. is a charity. You can actually donate to it, I found out today. But you do pay a little fee for this class, and it is, in a way, it's a charitable donation. But the point is about charities, that's one of 3 main beneficiaries that you can give things to, through your estate plan. or through a trust. And the others are of course, family and or friends. And to most peaceably and with the least amount of administration to pass money, property, land, or precious things to surviving family, friends, and charities, trusts are really good mechanisms to use to do that. So I haven't explained the first part, which is what are trusts, but I have emphasized one of the main points that I deal with when clients come to me is that they're often saying, I don't want to deal with probate. I know it can be a difficult process, and I've got a pretty difficult family. So we're headed toward a conflict. Something's going to hit the fan, and somebody's like losing their mind. Really, they're becoming incapacitated, and it often starts with mild cognitive disorder. It goes on to some general diagnosis of dementia, but believe me, doctors avoid putting on paper that this is straight up dementia because they know their records are probably going to be subpoenaed someday when there's a family argument. And so, where trusts come in quite often is to the second purpose in the first one, if it's avoiding probate, a second big purpose could be to keep the family together, avoid conflicts peaceably, as we say. Resolution of issues that one might know would come up is a great reason to have trust. So let me back up and stop putting, the cart before the horse as to what they do. So we know two good purposes right now of what trusts do, but what they are. What are trusts? So if I may ask, anybody want to volunteer what they believe, what they know a trust to be? Yes.
It's just partly when you talk about avoiding probate, when you have a trust, they're kind of like a law or a rule laid down, and it's harder to break a trust. So if you specified certain things in your trust, and this is to go to this person, and this person doesn't get anything, there's the way I understand it, they don't really have a recourse. A trust is a legal document, and you can't really contest a trust. Am I right?
Yes,
You can, but it's a lot harder.
Yeah, you can always
you're contesting in probate.
And so, you've got a lot of the key points to what a trust is. It is a legal arrangement, just like contracts are legal two-party arrangements. Trusts are three-party arrangements that lay down rules, meaning those rules are bound to be followed in who gets what, for instance. And the three parties we're talking about is that somebody creates the trust, and that person's called a grantor. It starts with a G. It's a grantor, Grantor, and they transfer some kind of property, which lawyers call property anything of value. It could be intangible property. It could be real estate. It could be titles on vehicles. It could be tangible personal property, straight up cash that's found in the mattress. It could be cash in the safety deposit box, or just other forms of anything of value. It's all property. And the point is that the rules are laid down of who gets what property and when, and how it's doled out. And it's the trustee that receives that property at the time a grantor creates the trust. So a grantor creates an arrangement, they lay down the rules, as you just said, Barbara, and those rules are bound to be followed by the trustee, and that second party, this trustee, goes ahead and doles out money or deeds or other things that are held now by the trust to a third party. What's that third person under a trust called? It starts with a B.
Beneficiary.
Beneficiary. Absolutely. Everybody knows about the beneficiary because beneficiaries also apply across a number of different instruments or accounts or properties of value with the beneficiary designation, like insurance, investment accounts, retirement accounts, etc. But under a trust, a beneficiary is that third person who can receive, for example, a check of money from a trust, and that is signed by the trustee, and it's made out to the, oh, what does that mean? It's 11? That's right. All right. So, what do we do about this recording here? I think we pause.
Let it go, just keep going.
This is the point in the recording at which we invite our listeners to take a breath, and we'll be right back. All right, trusts are these arrangements that are made where the rules have to be followed. Those rules are followed by the trustee. That trustee, as I was saying before the gongs began at 11 a.m., was that trustees pay out checks of money or they transfer property over to the benefit of a beneficiary, meaning they could pay money to a doctor and that doctor can service the beneficiary. Or the trustee could take the same money and give it to the beneficiary, and that beneficiary goes to the doctor. Those are called, for the benefit of the beneficiary. So what is a trust? A trust is a legal arrangement. It is an actual document and related documents that are executed at the same time. So the document sets up that a person or persons take some property, and let's say they take a whole dollar. It is enough property of value to have a person say that this day they're very intentionally being a grantor and taking something of value, and even if it's that $1 bill, or let's say a nickel, they say, I take that dollar and now I transfer it over into the hands of the trustee of my trust. And let's say, I don't know, Andy is married to Betty, and Andy says, Betty's going to be that trustee. Great. Betty receives $1, and Andy writes it into the trust, and he says that what Betty, if she's going to accept this position, because Andy cannot make his spouse, Betty, accept the position as the trustee, but he can nominate her to do so, and she can voluntarily accept that position. And if she doesn't, he can say, well, my buddy Charlie can be the trustee in the case that my spouse here, Betty, is unwilling or unable to be the trustee, just to have a contingency plan. As when these are written up, lawyers often and should always look toward contingency plans. What if things don't go as planned? Well, they often don't go as planned. So the contingency is that there's somebody to back up this second party, the trustee. As we say, Betty is backed up by Charlie, just in case Betty's not willing to spend that dollar on behalf of, let's say, our favorite niece, Denise. Our favorite niece, Denise, will receive this dollar, let's say over the period of the next 5 years, because she needs to know a little bit about money management, or there can be a purpose as to why money is paid over to Denise, the third party and the beneficiary. And yes, there's a question.
I thought a trustee could not be a beneficiary of any of those. I thought they had to be independent with no interest in the trust.
Well, that's an excellent point. That's an excellent point. And in this, okay, and so let me paraphrase that. It is your belief that the beneficiary cannot be the same person as the trustee, correct? Okay, that's an excellent point, but it's actually not true in most cases, even though there's some where it is true. Certain arrangements of trust, you don't want to make the beneficiary the same person as the trustee, but we'll get into those more complex reasons possibly. But figure it this way. On a trust where you have freedom to set it up any way you want, the trustee can be the same person as the beneficiary, or it can be different. And we were talking about three parties being a grantor, a trustee, and a beneficiary who respectively set up, spend, and benefit from what is put into and removed from a trust. So, now I hope this doesn't blow your mind or anything. All three of these people can be the same person. So we're talking Andy, the spouse, goes ahead and takes that whole dollar and transfers it from his Andy left hand to his Andy, the trustee, right hand. Andy's now the same person. He received, and he even wrote up all these paperwork saying that, I want to in some way benefit Denise and give her some kind of scrimpy lesson about how to spend money with this whole dollar, but I'll dole it out over the next 5 years, a penny at a time, and whatever the wild idea is, there's a purpose to the trust, and this trust we can say is not really set up to avoid probate. It's just to help Denise, right? And that's often the purpose of a trust, is how are you going to benefit the beneficiary? And when? It's how and when. So, when we look at these three parties going on, we started with Andy transferring $1 to Betty, his spouse, and him saying that if Betty can't do this as a trustee, then it's going to be my friend Charlie. And then the third person here is going to be Denise, our favorite niece, as a beneficiary. So that's the basic setup. Now, let's say things don't go as planned. And, Andy says, this trust has gone on for 2 years, and Betty thinks I'm just whacked trying to distribute $1 over the course of 5 years. Maybe I am, but I don't care. I put it in there. I get to change around this trust because I'm the one with the money. The one with the money makes the rules. Well, that's true with the trust. The one with the money or the property that's put to the trust makes the rules of the trust, and those rules of the trust are binding, meaning legally required to do so upon that trustee. So if Betty doesn't take the position, he's got the backup plan. He, being our grantor, Andy's got the backup plan for who is it? Charlie, his buddy, to be the trustee. So in this case, it doesn't go so well. And he says, Betty, I love you. And we're not going to blend our families or anything. We're going to stay together. It's great. I have my own estate plan. But I need Charlie to be the trustee. Charlie says, you know what? I'm living in India for the next 5 years, so I can't be. I'm just not able. It's not that he's not willing. He's not able. So he says, I'm going to do it myself. So then Andy becomes his own trustee, and he rewrites the rules by amendment to the trust that he established. And he rewrites the rules to say that, even though I didn't appoint myself as a backup, I'm going to appoint myself now to be the trustee. And Denise doesn't need the remaining 60 cents that are in there, so I'm going to write it up that I'm going to distribute to myself just to give myself a regimen, a routine, or whatever for fiscal discipline. I guess that's the purpose of this example trust. And he says, I'm going to distribute the rest of that money over the next 3 years to myself in allotments of 1 and 2 cents at a time at these certain times. And he can make out a schedule, or he can say, whenever I feel like it, just the balance needs to be paid out by the time 2023 rolls around. And so those are the rules, and he pays it out. And let's say before the 3 years is done, the IRS is after him. Or let's say Macy's, because he didn't pay his card. Those are creditors. And the IRS is a secured creditor because they're the first and foremost creditor that's going to collect on you, whether you like it or not. Unsecured creditors are the ones that haven't sued you and gotten the judgment yet. So my point is that let's say that it comes time for liquidation of this trust, and the 3 years has passed, but he is under creditor attack because he didn't pay his taxes, he didn't pay Macy's, and he says, I need to go to the doctor. And the doctor will take a payment of 60 cents. So because I don't want my 60 cents of the money in this trust to be at risk with creditors, I'm going to have the trustee pay that directly to the doctor. That eliminates everything left in the trust, and that trust, for all effects and purposes, is done. There's nothing left to it. There's no property left to fuel it. It's like gas in a car is money in a trust. So I've given you the basic components of what a trust is, and admittedly it's kind of amorphous or kind of without some shape and definition, and it is sometimes a legal concept that's kind of difficult to get at first. Now, any questions before I go on? And I do.
What if Charlie had died before the trust finished?
Then, if there's
And
no,
he hadn't thought about doing anything into the will.
well, there may or may not be a will involved. But if Charlie dies, let's say Charlie goes to India, that doesn't matter. He says I'll do it from afar, using the internet. But he passes away before he's done, right? So, legally speaking, if there is no trustee for a trust and the trust has property, that's called a lapse. There's a lapse in the trusteeship, I guess, of a trust, and it can be corrected and repaired by the appointment of a trustee, and sometimes you need to take that kind of a thing and ask the not the probate court in this case, but trusts go to the superior court. And that's one of the points about the separation of what trusts are and what wills are. So in this example, even though we bring up that what about a will? This one doesn't involve a will at all, and this one wouldn't involve probate at all, even though that's not the purpose of the trust itself. The point is that it's a separate jurisdiction. It can be corrected in lieu of a grantor being able to go ahead and change it, okay? So if a grantor creates a trust and it's a revocable trust, they can change it, and they can put somebody else in there by writing an amendment to a trust. But in the case that there is no successor appointment of a trustee, and there's no such provisions allowing, say, we write provisions that allow beneficiaries under a trust, the majority of them, to elect a new trustee of their own liking. Either it can be amongst themselves, or it, sometimes is defined as you can't make it amongst yourself. It has to be like the trust division of a bank to be a successor trustee. Anyway, the point is that trusts are versatile. They can be changed, and sometimes you do make trust to be unchangeable upon creation when there are complex structures set up, allowing things like, have we ever heard of a dynasty trust? No? Have we ever heard of an insurance trust? Yes? Some understanding? Some hearing of that. Have we ever heard of an ILET trust or an irrevocable life insurance trust? That's a mouthful. And it's not cheap. It is not exactly cheap to avoid probate, and that is the last word that we use to associate with anybody's estate or their estate plan. Everybody's plan is unique, it's individual, and trust arrangements are individual to the person and their goals. If their goal is that they want to teach their favorite niece, Denise, lessons about fiscal management, or if it's that they want to simply avoid probate, they, on the second hand, maybe simply, or in addition, want to avoid family conflict. I mean, Who here wants to avoid family conflict by a showing of hands? I think that's pretty close to everybody. One or two of you don't mind the family conflict, I see. So trusts help even that out. That's the bigger general point. But just reiterating these points one more time is that we've got three characters here who, A, as a grantor, create the trust, moving something of money over to B. This is Betty, in this case, would be our original trustee. And Betty's given all the permissions or some restrictions on how to write these checks or how to transfer these 7 family properties. And C, not Charlie, but Denise is the third-party beneficiary here. And Charlie's just there as a backup in case Betty, as our trustee, can't do it. A backup trustee is called, the legal term is called a successor trustee. So you've got your first successor trustee, that's just like a Miss America thing. That trustee really didn't win. It is your trustee, it's the appointment of your trustee, and then the successor trustee, the first successor is actually second. The second successor is actually your third appointment. So anyway, not to get too into the weeds on this, the trust should be set up in a reasonable fashion so that contingencies of what if this or what if that will be covered, and trusts are essentially fairly complex arrangements with a few basic components. So my encouragement is that do it carefully. If you want to do it at home, tread carefully. There, as I say in practice, from what I see, there's far more ways to go off the rails in doing your own trust than to stay on, especially when you're using a professional. Many people can create trusts, not just lawyers, whereas wills, lawyers are almost given exclusive jurisdiction to advise about that, because any other advice is practicing law without the license regarding wills. But on trust, the world is open, okay? Advisors or anybody can set up, just as people can set up contracts between two agreeing parties, you can set up a trust between two agreeing parties. Of our ABC structure, it's actually between A, Andy the husband, and B, Betty the wife. And C, Denise may not even know she's a beneficiary. She doesn't have to. And that in itself could be a whole course into the legal issues that deal with whether or not a beneficiary knows that they're a beneficiary. But we'll get back to that. Yes, question.
Is there kind of a basic rule of thumb? Because you have your grantor, and the grantor can change the trust anytime they want. But what happens, is there a protection if the grantor becomes mentally incapacitated? Are there protections you can write into that trust that protects him and the trust, them and the trust? Yes, that is to paraphrase and say that if a grantor can change a trust at any time they want, and they also possibly lose their mental capability, is their backups and safeguards so as to maybe preserve what's in the trust for the benefit of that person who's now starting to lose their capacity. Is that fairly accurate? So in the first place, trusts of the revocable sort, so you call them RLTs, revocable living trusts, those can be changed. Some other trusts can't be changed, but the point is that are there protections for the beneficiary, correct? The one who, or even the grantor, okay? So you got two things going on. The grantor, and they create the trust and they write the rules of the trust, at some point might not be able to write rules anymore. And that grantor names the beneficiary. It could be themselves. Let's say it is. Okay, and we have a situation where the grantor says, I'm going to put pretty much most of everything I have into that trust. I'll use it during my lifetime, but then in my incapacity, I want to make sure that my successor trustee, such as like maybe it's Charlie in this case, will be able to use
whatever's in this trust for the remainder of my lifetime with me being the principal beneficiary, me, the grantor, me, the beneficiary, still receiving that benefit. Yes. But if I'm the one that loses my mind and I'm the one who created the trust, that's beyond the point that changes can be made to the trust. So in a way that it practically becomes irrevocable after the grantor, who has the power to change, loses that power to have the capacity to make those changes. So, the trust itself. Let's get to more of the purposes of the trust. Okay, and question, yes?
I'm not sure I got this, and I think I had
Yeah.
the wrong impression of the trust. I thought a trust was one way to protect an asset from anything else. So I'm
Yes.
a multimillionaire, and I love my son, and my wife can't stand him.
Right.
And so they'd protest in my will. So if I put it in the will, my wife would scream and so forth. So I decided to create a trust to give $1 million to my son, bypassing the will.
Right.
Now I'm kind of a crooked guy. That's how I made a lot of money. And so I owe the IRS $500,000.
Right.
So IRS comes back and said, hey, we know you got a trust, and guess what? We're taking out of that trust $500,000. Can they do that? Or is that trust safe as it was?
That's a great question. And being a lawyer, I have to say that depends. Okay? All right. And here's why. Here's why. When did the conflict... So there's factors that are considered as to whether or not the trust property would be subject to collection by the IRS. Okay? So the factors. One factor is, when did the dispute occur? The occurrence. Second is, when was that given a disposition or a resolution? You know, there's a dispute period, and then they conclude and say, well, look, you owe $500,000. Like it or not, that's the number. Okay, so let's see. If $1 million is moved by a grantor into a trust for the benefit of that grantor's son, and that money is moved, let's say before that dispute ever occurred, was ever on the horizon, then that is safe.
Protected.
Protected so long as you make the trust irrevocable and the benefit to the son 100%. Or, 100% away from yourself. And in this example, you could make the spouse the trustee, for example, and make sure that you do not have the powers of appointment, which are appointment of, you call it corpus or principle of the trust. The power of appointment of the corpus of the trust would make you susceptible to collection by the IRS because you can give it to yourself, right? But if you do not have the power to make an assignment of the corpus to, like a gift to anybody else, then yes, that gift is protected. So I've named about 4 factors there that if it's not on the horizon, it's protected. If you make it irrevocable, it's protected. If you are not the beneficiary, it is protected. And if you do not preserve for yourself the power of appointment of corpus, then it is also protected. So very
would that
complex
be
answer.
The main reason why people created trust? Or not?
It can be the main reason. And so let me give a real example here. I spoke with somebody recently, and this person was recently convicted, but not sentenced yet, of a felony dealing with fraud, basically. And the IRS is owed restitution, and this person has not personally owned much of anything of value for the last 15 years. They have a spouse, and that spouse owns property of value, retirement accounts, domestic property, a second piece of real estate, investment accounts, a few titles on vehicles, and is also about 14 to 15 years older than the convicted and yet to be sentenced spouse. Now, it's a great set of facts, and it's real. So they are looking for protection of property. They don't care so much about probate right now, but they do care that the spouse who is not going to jail is almost 15 years older, and they're not spring chickens, when we say that, and there's, calculating it up, about anywhere from 500,000 to about $1 million in overall asset value, but I'll know more specifically soon. And so a trust is great in this situation for exactly what you're talking about, but in the converse, where it's not so much a gift of what's there, it's the protection of what's there for the remaining lifetime benefit of both the one who would create the trust as a grantor, as well as that grantor's spouse, just in case they should perish before that spouse, and just in case that spouse is incarcerated. The chances are extremely high that that spouse will be incarcerated. Okay? But can the IRS touch anything of what that spouse has access to as a beneficiary after the other not incarcerated spouse, as a grantor, sets up the trust? Is that convicted spouse protected, I'm asking? What do you think?
And so is this protecting the spouse from having creditors go after the one who's about to go to jail, probably, to protect them? And out of curiosity too, did the spouse have the money on their own originally, or did they get it together?
That's a good question. The second one first is we don't know, but we do know that there's two spouses and one does have ownership of everything and the other one doesn't. So, and your first part of the question was, how would you rephrase that, please?
All right. Our creditor is going to want money from the one who's about to go to jail. And
Yeah.
so do they have a right to go to the spouse?
Okay.
And are they trying to protect the spouse from having all, say, her money wiped out?
Right. No, that's a great question. Creditors can only go after the one who is the debtor, and only one spouse is the debtor in this case. Now, let's say the only creditor here is the IRS, which I know that is definitely one creditor, and there may be others. But if somebody doesn't own anything at all, then how much can be collected from them in any collection suit? Zero. Right. They can get a judgment of X amount of dollars against them, but that's the easy part. The hard part is actually collecting, because you can't get what from a stone? Blood from a stone. And that's the situation. You call them judgment-proof debtors. Okay, so now, in this situation, it's kind of complex, especially when you're dealing with the IRS. And they want to make sure that the spouse who's not going to jail will not have any involvement with the IRS if their property, through a trust, benefits the other to be incarcerated spouse. So that depends on the examination of, number one, did the not to be incarcerated spouse, were they convicted of anything? And the answer is no. Are they on the hook as a debtor to anybody? As far as we know, that's not the case either. So the extent to which this other spouse owns anything of value is the extent to which a collector, even the IRS, can collect. So, in this scenario, here's where the trust comes in. Is that let's say the stay-at-home spouse with the property creates a trust and says that I take something of value. Yes, this dollar and maybe a few more dollars. Let's say $10 in hand. Does that sound familiar from deeds? That these people, $10 in hand, they decide to go ahead and transfer a piece of property. Well, actually, deeds are often the thing that's put into a trust. And so this spouse can simply say that I take these two pieces of property and I live in one of them. Maybe I rent out the other one, or maybe the other one's an investment property. But I change the ownership from myself, my one singular stay-at-home spouse, and I go ahead and I change the ownership to the trustee of this stay-at-home family trust. It's a stay-at-home family trust, meaning keep the property home and keep it away from the collectors. But that's the main purpose of the trust, is property protection. And so in this way, the spouse who stay at home, who owns everything, says, generally, I transfer everything to that trust. And in a sort of as a side note, but as a labor-saving device, we use beneficiary designations of often investment accounts or insurances to benefit the trust itself once it's created, so that a grantor's financial life does not have to be turned upside down, and the ownership of all sorts of investment accounts or whatever has to be turned over to the trust. In theory, that could be done, but in practicality, it does not need to be done. What needs to be done on the stay-at-home spouse's creation of the trust is to create something where the rules are defined, it's on paper, it's defined to who's the trustee, and it's defined as to what property, even if it's deeds or a dollar, is going to be transferred into that trust. And they definitely sign that paper showing their intent to make this trust, and they say, you know, everything I put into the trust, or that will go into the trust by operation of my death if my trust is the beneficiary, everything that's in there will be in there for the remainder of my stay-at-home spouse's lifetime benefit, even when I lose my mind from mild cognitive disorder, dementia, Alzheimer's, Parkinson's, whatever you want to call it. It's very common that people do that, but it's also very common that their property is protected and it's cared for by what would be their first successor trustee, and it could be the spouse, it could be the friend as the backup.
Yeah, what I'm wondering is it set up so that the one who's in jail is going to be able to get access to?
And this is what you call the remainder. There's a first phase of the trust, and that's during the grantor's lifetime and or the spouse. So the grantor and the spouse are the primary beneficiaries. And yes, let's say the grantor spouse passes away while the incarcerated spouse is in jail. It could happen. And that trust now says that the remainder of this first phase of the trust is for the spouse and the other spouse's benefit, and that incarcerated spouse may take payouts from, let's say it's my friend Charlie as the second successor trustee, or maybe it's SunTrust, now Truist Bank's trust division, to be that backup trustee. But the point is, the trustee can only make checks out for the incarcerated spouse's doctor. Maybe only buy grocery cards at the supermarket, so that incarcerated or soon to be released spouse can access and have the benefit of without the ownership of those things in the trust. And that includes a place to live, which technically at that point in this hypothetical time would be owned by the trust, but it could be occupied, that is, the living in, by that now released, was incarcerated spouse who is bereaved because the other spouse passed away while they're incarcerated. So there we go. We've not even had the concern about avoiding probate, but the last phase of the trust, let's call it the second phase after the spouse, both spouses pass. Well, lo and behold, they got children. And let's say they're, one has 5 children and one has 6 children. That would be a blended family, right? None of the children have both parents. And it says, well, whatever's left over, distribute to the 11 remaining children. And, Charlie can do that. If Charlie can't, then Truist, SunTrust banks, trust officers, they can be, whoever's up next, they can be the trustee to distribute this to the 11 remaining children. And then that's the arrangement, and it's after the second spouse passed away. That avoids probate. That follows the rules that were originally set up by what we call the stay-at-home spouse, who had enough foresight to think of all these things and create this kind of a trust at home. No, just kidding. They often need the help of somebody like a trust and estates attorney. And this is not a plug, it's going to sound like one, but one who's experienced in creating these trusts and know what the roles are of a grantor who creates the trust, of a trustee who has to follow the rules of the trust and distribute, pay out things from the trust, manage the trust, deal with the beneficiary, and the third party, the beneficiary, who's always asking the trustee, who can also, usually in a family arrangement, that trustee is an aunt or an uncle, I'd say in the majority of cases. And that nephew or niece is always bugging the aunt or the uncle for the money and distribution, and aunt and uncle is saying, look, this I can only spend, and here's the rules that were set up by your grandparent stay-at-home. I don't know why they call it stay-at-home, but I guess there's some family secret, who knows. You don't have to reveal the family secret, but sometimes trust can help keep secrets, okay? Nevertheless, the point is, in the end, the trust that I brought up here is fairly complicated, but it takes care of the current generation. It protects also what is in the trust, what is in the family legacy, as you call it. What you have becomes legacy when it's passed on. And what people want with estate planning, sometimes the simplicity of that means staying away from the probate court, or it means avoiding family conflicts, or if it means having enough foresight to see that maybe the grandchildren, they might need a little bit of help, and even though they're going to get 1/11 of what's there, they have the option, for example, to take a distribution, of final distribution, after, hypothetically, they're the age of 30. But if they so decide, they can keep it in the trust for up to 10 years. And in terms of fiscal management, converse with the trustee on what kind of investments will, their piece, their 1/11 of the remaining property in the trust, where it will go. So trust, as you can see, can get very, very detailed. They can have very many good purposes. And we haven't even touched on, if I stand here for a little while, I could come up with 50 different purposes of a trust, or 50 different ways that we've written trusts. But they're wonderful estate planning devices. They're not an end-all, be-all, but what I also tell people about trusts are, be careful. It's buyer beware, because those who sell trusts do not are not often qualified to give legal advice. Lawyers, there's a real simple rule. Lawyers are licensed to give legal advice. If there's not a license, then that person might be a law graduate, might be an MBA, might be something, but they're not a lawyer without a license. And anybody without a license who, and this is not to say anything less of other professions that do financial management or do investment management, because those are absolutely necessary positions. But the point is that trusts are often quite confusing because anybody can provide them and they can charge anything that they want. And business-wise, I guess they should, right? If somebody's willing to pay way too much for a trust that they don't even know what it does, they're free to go ahead, and that's what I guess America's about. Spend your money the way you want to, but buyer beware, for sure. So thank you. I'm going to conclude now. We've got a few minutes left, and I would, three, actually a few minutes left, and I can take a few questions if we like. Do you have any questions?
I have a question
Yes.
here, and I know what your answer is going to be, but I thought I'd
Oh, that should be easy.
Anyway, yesterday I guess I saw on HSN or one of those channels where Susie Orman is promoting her latest edition of whatever legal package she has.
Was it scary?
Well, not really scary, but it just prompts me to ask, how safe are those kids?
Oh,
I would tend to think that it would depend again, on
well,
how difficult or
okay. How safe are the kits? They are as safe as the time and effort is put into it to understand what's being done. That answer is kind of circular, but I encourage people to get their estate planning done, whether it's a will or whether it's a trust, and whether they do it themselves or whether they hire a professional. Now, I can speak generally about Susie Ormond, and I think she generally does a good thing to make them aware of the estate planning, and I think she's based in California and California probate, as opposed to what we have here in Georgia as probate. California probate's more complex, and there's very good reasons, if you're a California resident, to get a trust-based estate plan. I've made California trusts before for people. They work, but generally I'd say yes. Yes, do estate planning, do a home kit if that's what the budget is, I guess. I don't know the pricing structure, but I think you can probably go anywhere from about $99 or $199 up to about $2,500. I don't know, $5,000. That's spouse one times two, But I think it's better that people are aware of the issues and they have the option to buy something to help address it. But yes, I have dealt with Susie Orman home kits that were flawed, that were fundamentally flawed. Lack of execution, lack of knowledge of how the gift is made, lack of knowledge that you can't gift something that is controlled by a separate investment instrument. For example, an investment account that pays out to my friend Charlie. Well, too bad, Betty's not getting it, even though the trust said Betty gets it. It still went to Charlie. And those things might be difficult to take the different moving pieces and parts. That would be, how do I own these titles to vehicles or boats, or how do I own these property, real estate titles, or these investments, or how do investment accounts differ from my retirement accounts, and how do those get over into my trust? Kind of complex situations, but those are all things that are actually not the trust itself, but should be connected or planned in a way that's connected to it. But how to do that takes legal advice a lot of times, or some maybe self-teaching or some applied knowledge to know how that's going to work out in the future. So that's a very long answer, but I think generally the world is better for having a Susie Orman and helping people realize that estate planning and trusts are very good to have.
Yeah, and
So,
I'm not
yeah.
trying to
Yeah,
say bad things about
but she's not a lawyer. I'm just kidding.
But anyway,
Anyway,
I guess the way that
thank
I
you.
kind of look at those things are that it's kind of like a universal
Yeah.
part for a car.
Yes, yes,
It
it
always
is.
takes some
Yeah.
All right.
machining to make the thing work right.
Yes, it does. It does. It needs tweaks and adjustments and maintenance to some degree. But anyway, that concludes everything today. Thank you for listening.